All right. Thank you so much for that introduction, Bernice. And thank you to everyone that took the time, to join this webinar tonight. Legacy One Law Firm, in connection with Bernice, who's been a gracious host for putting on these webinars. And we think we have something, really believe we have something special tonight with regard to legacy wealth preservation planning, which we like to think of planning for a lifetime of protection, of guidance, and of love. And so, what I'm going to begin here with tonight is having us focus on our why. So, the opening question we see on the screen here is, what is your why? Why did you join us here on this Thursday night? There's a number of things that you could have been doing with your time, but something motivated you or inspired you or encouraged you to say, you know what? This could be helpful to me, could be helpful to my family, to my business. So we're going to discuss some of the whys that we encounter as a firm day to day as we help and serve clients and families and business owners throughout the state of California. But before we jump into that, I'm going to briefly discuss what my commitment is to you tonight. I'm committed tonight to providing you and empowering you with information that we believe is life-changing. If you've ever talked about or discussed the possibilities of generational wealth or probate avoidance, we hear the terms having your affairs in order. Well, you're in for a treat tonight. If you want to learn, we're going to pull back the curtain on what happens when something happens to someone, when either at death or at incapacity. So my commitment to you is to give you a little bit of information that will help empower you to make sure your affairs are in order for your household. So back to the question of what is your why? For some of it's about family. Others, it's about comfort. Maybe not our own comfort, but maybe the comfort of those who we might leave behind if something happens to us. Others just want strategy. Strategy. Well, how do we pass down this generational wealth? How do we protect and preserve those assets that we've worked or spent a lifetime building? For others, it may be about taxes. There is a such thing as death taxes, believe it or not. Now, California is one of the states that does not have a death tax, but good old Uncle Sam, the federal government, does have a death tax, meaning, yes, your estate can be taxed at death if it reaches a certain threshold. So we're going to just touch on that briefly here this evening. For others, it may be about peace of mind, right? Are we up at night wondering, well, what would happen if something happened to me? What would happen to my spouse? If we're single, what would happen to my kids, my grandchildren? For some of us on the call tonight, the webinar tonight that are grandparents. So just the peace of mind of knowing that if something happens, that your kids are not going to fight over your assets. Your family might remain out of court and out of conflict. So what does peace of mind look like for you tonight? For others, it's about self-care, your body and your choices being honored. So tonight, your choices, some of us having total of assurance, peace of mind, comfort. These are just some of the topics and areas that we're going to cover tonight in our Wills versus Trust webinar. So, when was the last time you've had your existing estate plan reviewed? We typically have two camps on these webinars. There's the camp that we've done estate planning, we have some experience, maybe 15, 20 years ago, we've established a trust. Then we have others of us tonight that don't have a plan at all. Okay, so let's start off with the first camp. When was the last time you reviewed your existing estate plan? One of the number one ways that we see estate plans fail is that they're just outdated, plain and simple. 15, 20 years ago, we did a trust. 25 years ago, we did a trust. When we established this trust, our Kids were in elementary school. Now they're grown with kids of their own. So how much has changed since the last time you had your existing estate plan reviewed? What's subject to change? Laws change all the time. Beneficiaries changed. Your assets, you don't have this, you may not even have the same property you had 10, 15, 20 years ago. And then most importantly, what about your wishes? Have your wishes changed since you did your estate plan, however long ago it was? And that's the most likely, because sometimes when maybe your kids are grown, now you want something different from them, right? Maybe there's grandchildren now. Maybe the family has grown. Maybe the family, unfortunately, the size of the family has decreased. We've lost some people along the way. Your estate plan, one of the reasons why we call this a living trust is because it should evolve as your life evolves. It shouldn't remain stagnant. And on the other side, we have those of us who don't have a plan at all. Well, I have news for you. If you don't have a plan, the state of California has a plan for you, but unfortunately, you may not like what it is. And we're going to kind of pull back the curtain tonight and take a look at the state of California's plan for those of us who don't have a plan in place at all. So, what is comprehensive estate planning? We can tell you what it is. It's not piecemeal planning. We see piecemeal planning far too often, meaning, oh, I just have a standalone will. I have a standalone trust. And those are the plans that are often most vulnerable because they're piecemeal. They're not comprehensive. What is a comprehensive estate plan? It's one that's goal-oriented and solution-oriented, not merely focused on documents. Your life and your legacy is much more than a stack of paperwork. A comprehensive plan is holistic and integrated. It's not partial or piecemeal. Like I said, it's not just a trust here or maybe a healthcare directive. A comprehensive estate plan takes into consideration your short, intermediate, and long-term goals, not just what happens if someone dies. It's proactive and customized to your goals, not reactive. What do we mean by that? It's proactive. It means that it plans and thinks ahead. Reactive, we get the phone calls once it's too late. Someone's already died, it's too late. Someone's already been incapacitated. They're in the hospital now. It's an emergency. It's too late. It's going to cost you much more than if you had planned ahead of time. So that's what we mean when we say planning that's proactive versus reactive. Comprehensive planning involves having a trusted advisor on your side, not merely a technical advisor. And it's focused on achieving your goals and your overall vision. So when we talk about holistic planning, we like to picture a Venn diagram. I dare to venture that most of us on this call have experienced or at least heard of some type of financial or retirement planning. Some of us may already be retired. Some of us may be just embarking on the retirement journey, saving and planning for retirement. And we believe that much too much emphasis is put on financial retirement planning alone. And what's often missing is the estate planning. What good is it to spend a lifetime of building wealth if there's no plan or strategy to preserve it, to pass it down? Look, none of us are going to get out of here alive. And the things that we work for, we can't take it with us, right? We can't take anything with us. So we spend a lifetime of planning for retirement, financial planning, investment accounts, savings, life insurance. But if we don't take the time to estate plan, we can see that wealth squandered. And we can see that wealth sometimes end up in the hands of the state or federal government. We're going to talk about that a little bit tonight. So holistic planning involves both the financial retirement planning as well as the estate planning component. So there's two schools of thought when it comes to estate planning. There's planning for death and there's planning for life. What does planning for death look like? We see this young woman here grieving the loss of maybe a loved one, a friend, right? This is what most people think about when they think about estate planning. And we understand it's a taboo topic. None of us really like to talk about or think about our own mortality, right? But we all know it's the responsible conversation to have, or we wouldn't be on this webinar tonight, right? So here's the typical planning experience that we see. What we see out there, and some of you are probably familiar with this, it's a one-time transaction where either an attorney or someone you know who has their affairs in order may draft some documents. Some of us may even go online to try to find a template, forms and documents. We also see situations where it may or may avoid probate, may or may not. It may or may not avoid estate taxes. Often the typical experience leaves assets outright and unprotected to minor beneficiaries, or some beneficiaries are just not responsible or ready to inherit wealth. There's no ongoing legal guidance. Like I say, it's just a transaction. And here's what we see that's often all too tragic: the potential loss of your assets to the California State Department of Unclaimed Property. Then we have what we call planning for life, which we like to consider a whole new estate planning experience. An estate planning experience where you'll make informed and empowered decisions, which eventually save your family thousands in attorney and court fees, legal cost. Your assets are not lost at your death, but they're accounted for, they're planned for, they're passed down in a manner in which you decide. It can actually help protect your family from outsiders. What do I mean by that? Creditors, predators, bankruptcy, divorce. There's a myriad of ways with proper planning that you can protect and preserve the inheritance that you leave for your children and for your grandchildren. It's a lifetime of the right legal and financial choices, which will ultimately help keep your family out of court and out of conflict. So, will your plan work for you when your family needs it? So when we talk about planning from a financial perspective, this is what we're most comfortable and we're most familiar with, right? We see the commercials on TV about retirement planning, investment planning, planning for our children and grandchildren's education. We hear about insurance, right? Personal risk, financial loss, life insurance. We hear that. We hear about that. We hear about car insurance, home insurance, right? These different types of insurance things that we put in place. Planning for business owners, and I borrowed this pyramid from one of my good buddies who's a financial advisor, because I thought this was very helpful in putting our financial lives into perspective. So when we talk about strength in the universe, right, the pyramid is always kind of a symbol of strength. It can endure just by the way it's set up. It can endure the wind. It can endure the conditions. And at the base of that pyramid, that's where our strength is, right? And it all starts with money management, how we use and allocate our resources. So in that money management column, we see asset allocation, basically how we're allocating and using our financial resources, how we protect those assets. These are where your insurances and things are at. Taxes, what type of cash flow do we have coming through our household on a month-to-month basis or through our business? And then once we have the money management together, we can focus on goals now. Retirement, education, healthcare, purchasing property, giving to our church or charitable organizations, schools, things that we're passionate about. Then it helps us to gain what? Financial confidence now. We become confident in our finances at this point, right? We feel organized. How does this make us feel? We feel organized and in control. We're in a better position to take care of our loved ones. In the end, that should give us what? More time, less worry. And then at the pinnacle there, we're able to pursue our life's purpose and protect and preserve our family legacy. It's kind of at the top. So on the other hand, I mentioned earlier that if you don't have a plan, the state of California has a plan for you. And some of us as many of us on this call tonight, we've had a clogged pipe. We've had to call the plumber out because maybe the drain is clogged. And what does it look like when the drain is clogged? We got to call the experts out, right? there's either little or no flow to the water, right? And so we kind of liken that to the state's plan for you when you don't have a plan for yourself. In the state of California, if you pass away without a will, it's called intestacy. And the state has what we call default rules that will decide basically who gets what and when they get it from your estate. Okay. Some of us have heard the term probate. And I'm here to share with you firsthand. Probate is a beast here in California, and it's a process that you want to avoid. In short, what is probate? It's a lawsuit that is filed against yourself, against you, with your own money for the benefit of your creditors. And if we look at this kind of this flow chart here, if you will, or lack of flow, the first thing is someone's going to have to hire an attorney. If you passed away without a will, someone in your family is going to have to hire an attorney because now you got to go to court. And there's going to be attorney cost. Then if you own a home, like many of us do tonight, we own the homes. Now your home's going to have to be appraised. Someone's going to have to be the executor who's going to take charge and work with the court to kind of be a liaison between the court and your family. What if they have to get bonded? And this is a little secret that a lot of people don't know about not having a plan in place, is that the court can require a family member to get bonded now just to serve as the executor of your estate. Don't forget about court fees and court cost involved. And then there's creditors. Probate is a public proceeding, much like a bankruptcy, much like a divorce. It becomes public record. So now the creditors now have an opportunity to stick their hands into the pot to take from your estate. And finally, on the slow end here, whatever is left gets passed down to your children or your grandchildren, right? And then some of us have children, grandchildren, and relationships, or some of us may have beneficiaries that we may not want to benefit from our estate. But without a plan in place, that estranged son or daughter, or maybe an ex, maybe if you're a single parent, maybe you have an ex who you don't want to inherit from your estate. When you die without a plan in place, you open up the doors to all of those individuals to lay claims to your estate. So whatever's left now, there's some beneficiaries out there with their hand open. Some are rightful beneficiaries, right? There are kids, there are loved ones, but there's other relatives that can now lay charge or lay claim to what they feel they have the rights to, whether they do or not. That's up to the court now to decide.
Cedric, I have a question for you.
Yes, ma'am.
So this is talking about probate. What if you don't have property, but you do have savings and a person passes without a will? Would this same situation affect them?
Absolutely.
Their family?
Great question, Bernice. It's not just real estate. And that we get a lot of phone calls after people purchase their first home, because a home is such a large purchase. So we naturally think, I want to protect my home because it's the symbol of the family, right? It's our largest asset. But no, your bank account, even if you have $10 in there, right? Your insurance, your life insurance, that those proceeds can sometimes end up in a probate. Your retirement, we see retirement accounts all the time end up in probate. So it's just not real property that's subject to probate. Anything that you own that's in your name, even your personal property, to your jewelry, to your fine china in the cabinet, can all fall under the jurisdiction of the probate court if you don't have the right plan in place. So great question, Bernice. I don't want my listeners or viewers tonight to think that if they don't have a home, they're out of the woods, because probate encompasses all personal and real property, and including intellectual property for those who may have songs, movies, other types of intellectual property, trademarks, business intellectual property. All of that is subject to probate court, including, I say again, your business, because your personal business, if you own that business, or even if you're a partner in that business, if you don't have your affairs right, that your share of that business can end up in the public probate system. So very good question. I'm glad you brought that up.
Thank you.
So do we recognize these faces, right? Without even mentioning their names. These are icons. We all know about Aretha Franklin, Prince, Marvin Gaye. most recently, Chadwick Boseman, Barry White. What do they have in common? They all passed away without having their affairs in order. They all passed away without having a will. And once I learned, and one of the things that really inspired me to open up Legacy One Law Firm a number of years ago is once Prince passed away without a will. In fact, Prince's estate just wrapped up a 6-year, $180 million court battle because he didn't have a will. Now, we're not here to pick on these icons that lost their life, but they serve as an example, right? But this is not just for the wealthy. 60% of Americans in general don't have any type of estate plan in place. So whether you just you own one home, have modest savings, very modest investments and things of that nature, it applies to you too. But the thing is, because these individuals are famous or were famous, they weren't able to be a secret. They couldn't keep not having their affairs in order a secret because they were just too big for that. Okay. But let this serve as an example to us tonight that, hey, you know what? I want to do a little bit better. I don't have a $160 million estate, but I have a house. I have a life insurance policy that I'd like to see taken care of in a certain manner. And that's what this is about. It's not about us, but it's about who we're leaving behind. With that in mind, who are we leaving behind? Our children, our great children, great grandchildren, whatever applies to you tonight. Some of us may have adult children and it may not be grands yet. My son's only 7, so I'm in this category here. But you could be leaving assets to your children, whether adults or whether minors, outright and unprotected. Here's a question tonight. What would you do at the age of 18 had your parents left you a $500,000 life insurance policy? Here's a check, 500 grand. You were a freshman in college. How long would that $500,000 have lasted? For some of us, not even to the spring semester, right? The money would be gone, right? That first semester, you got a Porsche, you got a Ferrari, you're taking trips over the world. You're 18, you're not ready for that type of windfall of cash. So put yourself in your child or your grandchild's position. Some of us maybe have minors who can't even receive legally from us because they are under the age of 18. And so now that money has to be left with a guardian. And maybe you don't have the best relationship with that other parent or that guardian, right? And so now that money is placed in their hands. And now are you going to trust that $500,000 life insurance policy? That house, when it gets sold, where's that money going to go? That retirement, where's that money going to go? Will it be blown or squandered? Or will it be preserved to help maybe pay for college or pay for your grandchildren's or your child's first home, pay for a wedding? Make life a little bit easier for them than you had it. So with that said, for those of us who are parents, your kids could be at risk, even if you have a will. Now, remember, the title of this webinar was Wills versus Trust. And we're not going to try to, make wills the bad guy. But wills alone are a tool that only speak at death. And the will is designed simply to make a distribution of assets. The court does not have the personnel or the time to manage and supervise what happens to the life insurance policy that you leave to your kids, or the house that you leave to your kids, or the cash savings that you leave to them. And so, as I mentioned before, are your kids at risk with the plan that you currently have in place, even if it is a simple will? What about other types of assets that you might pass down? Estate planning can include several different types of asset classes. You have your non-retirement assets, such as like life insurance, cash assets. You have tax-free insurance benefits. And you also have tax reduction strategies. So it's not just about the assets themselves, but what type of strategy are you putting in place? I had one of my clients was inspired because she heard a podcast talking about Rockefeller and how the Rockefellers passed down generational wealth from generation to generation. And they did that through planning with trust, right? And tax strategies and life insurance, believe it or not. A lot of people frown upon life insurance and they don't see that as an asset. But if you have life insurance, you have something. So whenever I hear a client says, well, we don't really have anything. And then I look to see they have a $500,000 life insurance policy. That's nothing. Somebody's getting $500,000. What are you going to do to set them up the right way to receive that $500,000? So that's what we mean by strategies and different ways to pass down inheritances. And some of us just don't know what we don't know. So do we really know what to do with that? And that's what professional guidance is here to do, to help show you, well, these are what our other clients are doing. These are what some of the icons in the past have done. You don't have to be wealthy to have a strategy. And sometimes when you're not wealthy, you have more to lose, right? Because you can't afford to make some of the mistakes that the wealthy could make. So I mentioned earlier that this was not just about death and despair and passing on, but what happens if you survive an encounter? You go out for dinner this weekend and you're seriously injured in an accident. Who will be there to make these important, critical healthcare decisions for you? Will your loved ones be scurrying? Will your loved ones have to get the court involved? We see that much too often. Clients call us and say, hey, my loved one was in an accident and now the hospital won't give us information. What do we do? Unfortunately, you're going to have to go to court. I'm going to have to refer you to an attorney that specializes in that. So thousands of dollars later, now you get the answers from the hospital. That could have been taken care of. What if we can turn your wishes, what you'd wish to happen to your body, if you're ever incapacitated, we can help you turn those wishes into directives that have to now be followed. Additionally, your health is invaluable, right? But what about your assets? If you're incapacitated, who will make important financial decisions for you when you cannot speak for yourself? Is the mortgage company going to give you a pass if you're down for 60 to 90 days? Are the credit card companies going to say, oh, you know what, we understand, right? The bills are still going to have to get paid. The car payment's still going to have to get made. But who's going to do that for you? Who's going to step in your shoes when you cannot to make those financial decisions? The good news is there's a strategy and a solution for that. And we're here to provide that guidance for you.
Cedric, I have another question.
Yes, ma'am.
You're talking about incapacity, but for couples that are married, does that matter if one is incapacitated and needs to, healthcare decisions need to be made? Can't the other spouse do it?
Not automatically. And that is a big slap in the face to a lot of my clients who are married. They think that just because we're married, that the spouse automatically can make decisions regarding their health. And no, each individual has their own medical personal privacy. There's HIPAA laws out there. A lot of us on this call have heard of HIPAA, right? HIPAA does not automatically extend to spouse. Your spouse may not want you to know all of their personal medical history. And there's been countless lawsuits in the past where hospitals have revealed information about someone's personal medical history because someone was sick or incapacitated and the hospital gets sued. So now, because of that, you have to have the right legal documentation, the right authority to even have your spouse make critical decisions. And what if your spouse's wishes aren't your wishes? What if your spouse, and it's not as simple as, well, I told my husband or my wife and they know what to do. Will they have the power to do that? Because if you haven't given them the right legal documentation, that spouse can say, hey, my loved one said they wanted this, but the hospital doesn't have to listen to you. You have no legal leg to stand on outside of the right directives put in place. So yes, the answer to that question, no, the spouse does not automatically have power. The other spouse has to give that spouse power in writing to make certain healthcare decisions for them, and also to have access to their personal medical information. And that's really what the hospitals are afraid of. They don't want to get sued by sharing some personal medical information that was personal to that individual, not to their spouse. So a very good question. And that's something that's often overlooked and taken for granted.
And then one more question before you continue, I'm sorry. So again, spouses and financial decisions. Because I'm married, can I automatically make or sign or take over financial issues for my spouse if he becomes incapacitated?
Well, that question is, it depends. Is this a joint checking or savings account where both spouses' names are there? Well, then you're not going to have a problem, because if it's an asset that's shared as community property together, or it's an asset that both individuals' names are on that account, then there's not going to be any problem. But a lot of spouses, they come into the relationship with separate houses, their own bank accounts. Some spouses keep their stuff separate even when after they get married, right?
Right.
And so now, if you have a spouse that has $10,000 in the bank account that you need to get access to care, you're not on that account. Just because you're married, you're not on that account. You would need a power of attorney, just like a girlfriend would, or a boyfriend would, or a sibling or a child would. So marriage does not provide a blanket of rights to manage the other spouse's separate property. You do not automatically have that right unless the other spouse legally and in writing gives you the power to manage their own affairs. Does that make sense? So we have to be very careful. If it's something that's jointly owned, not a problem. If they have their own bank account, you have your own bank account, potential problem.
But what about if we've been married forever and I've signed his name forever? Is that okay?
Well, that's probably forgery. It is forgery, actually. So you may not want to admit that in certain spaces because it's forgery. But no, that won't be recognized. A financial institution is not going to let you sign your husband or wife's name on their behalf, because that is against the law. That's forgery. You'll need an executed power of attorney to be able to sign on behalf of that other spouse.
Okay.
But very good question.
The last question, and you may come up to it, but in the chat, someone asked, what about children, adult children? And does parents need healthcare directives or power of attorneys for adult children over 18?
Well, absolutely, because they're your children, and they're going to be your children until they're 99, right? No matter how old you get, your babies get, they're still your babies. But there is the legal cutoff for that. At the age of 18, you no longer have jurisdiction. You're no longer their guardian. You're no longer, they can stay on your insurance, but we're not talking about insurance. We're talking about making legal choices for them. So the answer to that question is yes. Yes, if your children are 18, whether they live under your roof or if you have a 40-year-old that's still living in your basement, right? We hear that joke around, the 40-year-old person who still is living at home for whatever reason, right? Some kids, you're not going to be able to get out of the nest. You have their name on everything, but you can't make decisions for them legally. They're adults once they hit 18. So great question.
And then the last one, someone asked it in the chat, and then I'm gonna stop. So just to confirm, so regarding individual bank accounts, would a husband need a POA to benefit from my individual account?
Absolutely. If its name is not on the account. Okay. And one thing I do want to add here is that adding someone's name on the account is not estate planning. And we're going to get into that, why that it's not. That's not a plan. That's adding someone's name. And a lot of times we see tragedy strike when both people pass away now. And now what? That asset goes right to probate. Adding people's names on the account, that's not an estate plan. That's a temporary thing. Then when most people learn about estate planning and how it works, they say, oh, well, I got it wrong. But yes, if you have signers on the account are signers on the account. So if you have multiple signers on the account, legally, all of those individuals, upon showing valid identification, right, can manage those accounts if their names are on the account. So we'll try to, for time's sake, we'll try to hold the rest of the questions for the end so we can make it to the presentation. Please, if you have questions, stick around to the end. I promise I'll leave time to answer your questions. So what about some common planning techniques that don't work? I just kind of mentioned it, right? Owning property jointly, whether you're putting a child's name on the house, that doesn't work. Putting a child's name on the bank account, that doesn't work. Why? Because beneficiaries are ones that we love and we trust, and they're often close to us. And there's so many holes with that. If they pass away in a car accident with you, if you pass away and it all goes to that one person, we're trusting them to share it with the other kids. And this is how we see fights. Mama put one child's name on the bank account, and now the other kids are at that other child's throat, wondering, are we going to get this money? That child is not legally obligated to share that money that they're the beneficiary of on that bank account. So that there's a myriad of different things that go wrong when you don't have an estate plan, but you put someone's name on something. So that's that designating a beneficiary. Beneficiary designations fail all the time. So how about owning property jointly? We mentioned that. What about just signing a will, right? We talked about the problems with signing a will if you have children under the age of 18, if you have grandchildren under the age of 18, if you don't want the things that you work for to go through the probate process. Yes, because if you have a will, you're going to probate. So signing a will is a planning technique that often does not work the way that folks intends for it to work. So with all that in mind, there's only one foolproof way to avoid court. One way is you can die broke, right? And have not a penny or a dime to your name. But how many of us want to do that? You wouldn't be on this call if you wanted to die broke and desolate without a penny to your name. For the rest of us, there's one way, okay? And that's a fully funded living trust with the appropriate disability provisions. I say that again, a fully funded living trust with the appropriate disability provisions. Think of your trust as a treasure trove. That's why we have this treasure chest here. And over your lifetime, you're able to have your trust either owned or control everything. Your investment accounts, your bank accounts, your real estate, your stocks and bonds, assigning all of your personal property to your trust, your cars, your jewelry, your family heirlooms, your priceless pieces of memorabilia that have no price tag, they're priceless. All of that can be managed and controlled through your family trust, completely avoiding the court and avoiding the risk of being lost to the state or federal government, including your life insurance policies. I left that part out. Your life insurance policies and retirement as well can be all controlled by your family trust. So what do I mean when I say funding your trust? Funding your trust means, hey, this is one of the number one mistakes we see. We see this often for people who try to hire a non-professional or a paraprofessional, maybe a paralegal or somebody who's not licensed, or maybe they just take upon the task of doing it themselves. They often forget to fund the trust because they just don't know to do it, right? And so, but what can you fund the trust with? You can fund it with both non-retirement and retirement assets. And here we list those non-retirement assets: your bank accounts, your investment accounts, your real estate, your life insurance. Then we have your tax deferred and retirement type assets, such as your 401ks. You have your individual retirements, your IRA accounts, the different types of 403B and 457 plans for people who work for the state government or federal governments, right? So with that in mind, who else wants to protect their inheritance completely? Then we move into good old Uncle Sam and estate taxes. I mentioned earlier that the state of California does not have estate taxes. They tax us enough while we're alive, but our good friend Uncle Sam does. The good news here, if you're a married couple, right now the exemption is so high that you say, hey, that's rich folks' problems, we can move on. 23, over 23 million, because the husband gets 11.6 million exemption, the wife gets 11.6 million exemption, and you can combine that if you're married. So your assets would have to exceed 23 million as of today. However, in 2025, this is going to change. And it's going to change and drop drastically and significantly, that it's going to affect many, many more Americans. So this is a little bit inflated. I have some colleagues that have been doing this so long, they remember when this was $1 million. Not too long ago, it was $5 million. The federal estate tax is subject to change because it's voted on by Congress. So when we get together on our one-on-one session with your family, we can discuss whether or not you can be in danger of estate taxes in 2025 and what we can do about that today to ensure that you're not taxed or you're mitigated. Your taxes are mitigated with the right type of tax reduction strategies. So what are some estate tax strategies? We're not going to get deep into this, but there's gifting strategies. There's different types of trust that you can establish. There's various life insurance policies and more. So if you may be in danger of an estate tax, and we'll only know if we have a discussion together one-on-one, we can discuss whether or not you're in danger of an estate tax. And if you are, we can certainly discuss some estate reduction strategies to help you mitigate or minimize tax liability. So we've been talking a lot about money and things and objects, but here's a question for you. If you had to choose between the people you love receiving your money or your values, your insights, life stories, and life experience, what would you choose? What if you can do both? What if you can both pass down? You don't have to choose. That's the thing. With the right plan in place, you don't have to choose between simply passing down values. You can have a plan in place that takes into consideration your family's values, cultural traditions, in addition to passing down that wealth. And you can even place contingencies on it, something that you can't do with a simple will. The proper type of estate planning is the closest thing from speaking from the grave that's out there. Talk about, hey, my mama speaking from the grave does mama have a trust? Or because that's the only way that mama's going to speak from the grave is that she has a trust. Okay. And that's one of the things that we help when we talk about planning for generations to come. You can pass down both your family values, cultural values, in addition to your assets. So with that said, you can kind of get my drift here that there's no one size fits all estate plan out there. And this is one of the common issues that we see with this. And why our phone rings from loved ones who someone's passed on, and like, why are we still going to court? My mom had this trust. Why are we going to court? We have this will. What do we do next? These are the issues that we see. The first one, we see planning that's just based on documents and forms. This is the common DIY approach with the online. Look, the internet is both a blessing and a curse in so many ways. We live in the information age where we have all the information and knowledge that was ever existed during the time of humanity, right? It's all online. But what do we do with that information? And the problem with the DIY approach is we don't know what we don't know. And with this type of planning, if you make a mistake and you pass away, it's too late. If you make a mistake and you become incapacitated, it's too late and it's more expensive. Okay, so save the DIY for the home improvement project. If you mess up the bathroom, you can call a contractor, right? If you fix the car and you get the engine wrong, you can call a mechanic. But if you get this trust wrong, if you get this planning wrong, it can impact your family for generations to come. So also with that one size fits all approach, it doesn't keep your assets out of the California State Department of Unclaimed Property. Assets go unaccounted for too often. It also leaves your kids at risk of squandering wealth or from creditors, bankruptcies, divorce. Some of us have kids that we don't like their spouse. And we're saying, hey, you know what? That person, I do not want them inheriting my inheritance, right? If you don't have a plan in place, that inheritance is vulnerable to that spouse, right? That's one example, not to pick on spouses, but we see this a lot. And finally, a one-size plan only addresses financial assets, not what matters to most. Remember, you're more than just legal documents and property. You have a family legacy and people who you love and you care about. So protect those. So as we get ready to wrap up here, how do we get started? How does this all start? Well, at Legacy One Law Firm, we have something that we call the Family Wealth Planning Session. What that is, that's a meeting where I'll sit down with you and your significant other, if you're married or a domestic partnership, or if you have a life partner. The three of us will sit down together. If you're single, we'll sit down together one-on-one. And we'll take a look at what would happen right now under California law based upon your individual situation. Remember, this isn't a one size fits all. We want to talk about what's going on in your family, right? What's unique to your family situation that you want to see protected. So that family wealth planning session is where it starts, but there's one step before that, and that's a phone call. A phone call. So before we can schedule that big meeting, I want to talk to you. I want to find out, what are your hopes? What are your fears? What are your values? What is the number one thing on your heart that you want to see get taken care of from this important planning? And that will start with that 15 to 20-minute phone call. It's a free consultation. In fact, Bernice is going to share in the link only for the people that are on this call. She's going to share a link to my personal calendar. Yes, I'm going to share my personal calendar with you so you can pick the time that works for you to have that 15 to 20-minute free consultation so we can discuss how we can get started. So before you get off this call, write in the chat. You're going to be able to link my calendar, and we have a few appointment slots left. I'll discuss that some more at the end for the month of January, where you can still get in and actually get some planning, get started on this important planning. And so the purpose of this is so you can make more informed and empowered choices. You don't have to go through this alone. You don't have to be overwhelmed with paperwork and documents, okay? And I know some of our wheels are turning saying, well, how much all this is going to cost? Is this going to cost me a small fortune, an arm and a leg? Well, look, one of the beautiful things about the way that we serve clients and serve families is that we don't believe in an hourly bill. We don't do business that way. We have planning packages that you and your significant other will choose from. Okay, now we have 3 levels of planning. They start on the low end at 3,000. They go as high as 6,500. Don't get intimidated when you hear 6,500. Everyone's in a different financial situation. We have some clients that have more money than they have time, right? You will discuss when we're on the call with you what your unique family situation is like, and we can find the plan that'll work for you. Okay, all of our fees are agreed to in advance, so there's no surprises. And as an added incentive for everyone that took the time out to join us for this webinar tonight, we have gifts. Everyone likes gifts. The holiday season just passed, but now we can start off with some new 2023 gifts. The first thing that we're going to offer to everyone that's on this webinar tonight is a gift certificate for a legacy wealth planning session. That's just like that family wealth planning session that we mentioned a few minutes ago. We typically charge $750 to have a family wealth planning session for members of the public that just call into the law firm, because we have to pay for the time that we're going to spend doing this. But if you're here on this call tonight and you mentioned that you were here, Bernice has a roster, a list of everyone that was here, then we can extend to you that legacy wealth planning session at no charge. Secondly, we have a $250 discount that will go toward our trust or our wealth plan. Our trust plan, our wealth plan are just 2 of the 3 plans that we have to get started with planning. So that's $1,000 in savings that Legacy One Law Firm and me as the CEO and founder of Legacy One Law Firm, I want to pass on to you. And I want to use that as encouragement for you to reach out and give us a call, because we don't want to get the phone call from the relative or from the significant other that says, hey, this happened, tragedy has struck in home. What do we do? You can have peace of mind knowing that your affairs are in order, that your kids are not going to fight, your family's going to remain out of court and out of conflict. And so we just want to use this $1,000 in gifts as a way to encourage you to step out and make this phone call and get on my calendar and set up a time we can talk one-on-one. If you're married, please schedule a time that your significant other can be on the call. So that way we don't have to make 2 phone calls. We can just have 1 phone call with you and your significant other so you can take care of this important life planning. And with that in mind, with that said, thank you so much for your time. I will now turn the meeting back over to Bernice, where she can open the floor for any questions.
Thank you very much, Cedric. Really appreciate you for the information that you shared. I know that I was asking some questions before, and these were questions that were others have asked prior to the meeting. Now, for those of you that are here and you have questions that has not been addressed, feel free to raise your hand and or unmic yourself and ask your question.
Good evening. Can I speak
Yes.
now?
Yeah.
Hi, my name is Shelley Givens, and I don't have a bunch of money. I don't have own a home or anything. I'm just a single person that lives in California by myself. I don't have any children, no parents. I don't have anybody, but I wanted to designate my niece to take care of my affairs. I don't have anything, just to be able to access my bank account and my apartment so that she could clear it out and officiate over my services. And so my whole thing is, why I sat in with this is like, how do I do that properly? You know, I thought about writing out a letter and saying, this is what I want, and having it notarized. I want to know how to handle that properly. I don't have $1,000 to, you know, because I don't have any money. I'm not but I just want my affairs in order, and I don't want to wait until I'm dead, like you said, and they're passing the hat and figure out who's doing what. I want to take care of that now responsibly.
Absolutely. So great question, Shelley. Thank you so much for joining the webinar. And with this planning is for anyone who cares about what happens to their body and what happens to, you know, their loved ones, their things that they have, whether it's very modest means or maybe whether you're a millionaire. So yeah, there is a proper way to get this done. And I would advise using at least a will at a minimum, at least a will, and your healthcare directives, powers of attorney, your California Advanced Healthcare Directives at a minimum. Okay, so I'd love to have a conversation with you to talk about your personal situation a little bit offline if you'd like to schedule an appointment. But what you certainly don't want to do is just write a letter and have that notarized, because that is not a will. That will not be recognized in the state of California. It has no legal gravitas to it at all. And so writing a letter and signing it is not a will. Okay. And so you want to make sure that you're getting the proper guidance, even if you feel you have very modest means. Let's have a conversation. The conversation that we'll have is not going to cost you a dime. And so if we have a one-on-one call, we can discuss maybe if there's some alternatives that may be for you, but I'm going to make you call me for it. Okay. You're going to call me, so that way we don't put your personal business out there. We can just talk about what your personal situation is one-on-one and see if there's a solution for you, whether it's with our firm, whether it's with someone else. There's a solution for you out there. Absolutely, Shelley.
Okay, thank you very much.
You're welcome. I hope to hear from you.
You the 323-405-7017, correct?
Yes, ma'am. And you can also use the link that Bernice put in the chat to schedule an appointment directly online.
Okay. Thank you.
Thank you. You're quite welcome.
Does anyone else have any other questions? Feel free to unmute yourself. Okay, while you're thinking of your question, there was one that was written in the chat. So yes, I did post the link for Mr. Collins' calendar in the chat section. So all you have to do is click the link and it will take you directly to his calendar, and you can choose a date and times based on what's listed there. Now, there is a question, Cedric, that's in the chat that says, if you have a trust already, can you revisit it?
Great question. Yes. And in the beginning of the presentation, remember, I had the picture of the young man, the gentleman, and the other picture saying, hey, there was two camps. There's those of us on this call that have already done some estate planning, and there are the camp that has not, because there's no in between. Either you've done it or you're not. And first of all, I commend whoever has done that for taking that step. However, your estate plan could be outdated. It can be old. And that's one of the number one ways we see estate plans fail, because they no longer reflect your wishes. So we do those all the time. In fact, we get plenty of clients that call in and say, hey, I have a trust from 15 years ago, 10 years ago. Does it need to be revised or updated? If you schedule a call with me, it's still free to you too, a free consultation. We can discuss when your trust was established and what's changed. Because if it's good to go, it's good to go. And we even have a 50-point trust inspection that we can put your trust through to determine whether or not it's vulnerable. So just like when you take your car to have a diagnostic at a dealership, the mechanic, we can run your trust through a 50-point inspection process to see and determine whether or not it might be in your best interest to have it amended, revised, and updated. But very good question. Please do reach out.
Thank you. And then there was another question. Do estate plans, once you have a living trust, does it have to be recorded with the courts?
And it's a great question. No, it does not. And we advise that it should never be recorded. When you have a will is recorded at death. So if you have a will, that's not going to get recorded until you've passed away. But with a trust, you can. I've seen maybe a couple throughout my career that were recorded, and I thought that was very odd, because one of the things that you have when you use a firm to do private planning is you have privacy. If you record a will, it becomes public, a trust, because you can't record a will. If you record a trust while you're alive, it becomes public record. And so now all those gifts and everything that you're leaving to your kids now, the world can see. And so now that's kind of like exposing your privacy. So the answer is no, you don't need to have anything recorded in California at all. In most states, the answer is no. Okay. And if you want to discuss whether you should, then we can have a one-on-one conversation to discuss whether or not you should. The general rule is no. But if you have special circumstances, they have to be very special, then you might want to have something recorded with the county. But in most cases, I've never personally recorded a trust for a client. I'm saying will because wills are recorded when someone dies with the court, the probate court. But once you're alive, your trust, no.
And then another question that was asked prior to this meeting, if a person had a living trust, established a living trust recently, and the family member died, and a will from 20 years ago came up, would that will supersede the trust, or could it?
Okay, so if somebody had, let me understand this question correctly. There's a family trust now, but there's a will that pops up, but somebody's already died, but there's a trust that's found, and then there's an old will.
Right. Okay,
now, those two documents could be in conflict with each other, right? So if that will that was found 20 years ago was later revoked or revised, the newest will is going to prevail. Okay. Now that old will, if it conflicts with the trust, you could have a legal dispute on your hands. You could have a will contest. You can be that's court. It could be potentially court.
Okay.
So what I would advise, if that is a situation that I can't offer legal advice to anyone on this call. This is all just general information. But I would advise reaching out to if someone brings it up, right? Don't go waking up a sleeping giant. But if somebody brings it up, you want to get a trust or a probate attorney who does litigation to maybe represent you or defend you in that case. Because yes, if those two documents are in conflict, because remember, a trust is different from a will. and they're handled differently. So if those two are in conflict, it could cause a legal dispute within the family. But if there's no dispute, that person's already passed on, and please don't go waking up a sleeping giant. But if someone does sue you, then you're going to need the appropriate attorney to represent you in that case.
Okay, Oliver.
This is also why estate planning is so important, and to make sure everything is up to date and not done yourself, because that person could have set that up and didn't know that they were doing anything wrong.
Okay, thank you. Oliver, you had a question?
Yes, I want to ask the question now. I have 401ks and bank accounts in different financial institutes. And is it better to have beneficiaries on each one of those accounts, or should I have a living trust to where they're all stated in a living trust, or should I have both?
Well, here's the thing. You don't want to have both, because that can cause confusion with your financial institutions. You have a trust and you have all these people. It's a nightmare for them. More room for error.
Okay.
The way that we advise families is your trust should be your beneficiary on certain accounts, right? Now, if it's retirement and you have a spouse, right, your spouse can be the primary person, right? And then your trust can be two. So I don't know, are you married? Do you have a spouse?
Yes, I'm married.
Okay, so so if you have your spouse there with retirement only, the spouse is the primary beneficiary under law, right? So, but what if something happens to you and your spouse?
Okay.
Now there's a problem, right?
Okay.
And if you put a kid on there, one of your kids, well, what if something happens to that kid? Or if it goes to one child, now is that child not going to be responsible for distributing it to everybody else? And do they have to figure out what you wanted to do with that money? And so there's a myriad of problems that come with naming beneficiaries, because naming beneficiaries is not an estate plan. It's not a plan. It's just a beneficiary designation. Somebody's just getting a check. You have no idea what they're going to do with that check.
Okay, because my plan was to make everybody equal accounts and have, would it split up 33% of each, because it's 3 kids, 2 kids to my wife, and so everybody gets their percentage, and that way nobody has to worry about who gets what. It's already there.
Exactly. And the only problem with that is, well, what happens if, here's going to give you one quick contingency. You have 3 kids. How old are your kids? How old are your kids? Do you have any grandkids by any chance?
Yes, I have grandkids too.
Okay. So one of your kids dies, who you give the 33%. What do you want to happen to that grandchild's child's share?
Okay.
What happens to it now? Does it now just go to the other 2 kids? And now the grandkids of the children of their child that died, do they get anything? Do they get now forgotten about? Their parent died. Do you want them to get their parents' share?
Okay. So
right?
The trust then.
You see what I'm saying? See, a benefit that the banks, they don't want to deal with all of that. They're not going to deal with, they're going to ask trust. Do you have a will? Because it's not their job to figure out if somebody died, who should get all this money. And so that's why beneficiary designations, they don't work, because the banks and institutions, they don't have time for all that. They've got time. They want to get up somebody a check. But you have unique family dynamics. You got grandkids. What if you want to pay for your grandkids' college education? What if one parent dies and you want that money to pay for their kids' first house or college or something? You can't do that with just a designation.
Okay.
With an estate plan, you can, because it's a plan that's legally enforceable, versus just a beneficiary. Well, the bank doesn't know what to do now. Somebody died. Send it to probate.
Got you.
So that's the problem with just putting beneficiaries on there and not having a written plan that's executed the right way.
And another question I want to ask, because it happened to me, my grandfather had a living trust, and since he didn't apply me, he left everything to me, put me on his house and everything, but he didn't apply me to the deed to his house. So once he passed away, the state of California increased the property taxes to today's property tax, instead of putting me on there and having it all together to where I could have received his property taxes.
Okay. Yeah. So Proposition 19, old Prop 58. So the house came from your grandparent. You said your grandfather?
But when he died, my mom was still alive, but he didn't leave
That
it.
was your problem. Your mom
Yeah.
was still alive.
Yeah.
That's the problem. And see,
Yeah.
because what happens is I have a client that dealt with that recently. You have to, the second generation has to pass away to be able to get the exemption from the granddaddy. So if your mom could have got the exemption, but as long as your mom is still alive, the law doesn't allow you to generation skip that way.
Now,
That was the problem.
can you go back and revisit that even though, or no, it just has to happen before your grandfather passes away? Or
Well, the thing is though, the law is you can't revisit the law.
okay.
You see, so your grandfather's already passed away. He's already passed the house. How long ago did he die?
He died in 2008.
Yeah, it's a long time ago, right? So, so the property tax assessment, I already know right off the top of my head why you didn't get it, because your mom was still alive. And so you can't go back and reverse anything because he already gave you the house.
Yeah.
You see, and he's already passed away. You see, and so this is where he probably didn't have the advice when he was doing all of this, which a lot of our parents and grandparents don't. And so they think they're doing the right thing, but if he did the right thing, you'd have his basis, his tax basis. You could have passed it through to you through the right way, or put certain provisions in there so you can keep the step up in basis. But because your mom was alive, and you say he tried to do that through his trust, but the court didn't recognize it.
Yeah.
Yeah, it's because your mom was alive, and he wanted the generation skip, and it's tough to do that.
And so what happened is that he didn't go through a lawyer, or he went through just a paralegal, and I don't really believe she knew exactly what was needed to do as far as to put my name on the deed and all of that good stuff. And like right now, I have an uncle of mine, he's trying to do the same thing, and I'm trying to make sure I give him the right information, because that's why I thank God that you guys had this webinar today to give up this information. I wish I could have sent him the link so he could have seen it. He lives in Hawaii. But the problem is that I don't want him to do the same thing that my grandfather did. You make the mistake, because if you're going to leave me something, then you're leaving me this financial burden, because he don't have any kids or anything like that. I'm just his nephew. So, with all of this being said, I don't want him to make the same mistakes.
Then definitely have him reach out to an estate planning attorney in the state of Hawaii. Okay. Absolutely. And do it the right way, because when it's not done the right way, it always costs the family more in the end. Yeah. It always does, folks, because we think that maybe money is tight, but it's better to scrape to do it the right way, right? You just like you scrape to get that house when you first bought it, scrape to get a plan together. So that way it doesn't cost your beneficiaries a lot more money in taxes and things of that nature. There's a way to pass things down to help mitigate taxes, and then again, if you had a paralegal set it up, they probably didn't do the deed right. And there's a lot of things that happen. So yeah, you just don't want to put names on deeds arbitrarily. You always want to get legal advice, because once you put a new name on the deed also while a person is alive, it has more tax implications as well. And so you want to make sure if Hawaii has certain exemptions, you want to make sure it's done the right way so the kids and grandkids qualify for the exemptions.
Okay.
And the paralegal, most of the time, I don't want to say it, I can't speak for all paralegals, but they probably didn't know. And they're not held legally responsible because they're not licensed professionals. They're paraprofessionals, where attorney is licensed by the state. And we have a fiduciary obligation to make sure that we do the job the right way for you. That's why we have insurance, because if we don't, then we could be liable.
Okay, thank you.
Paralegal can't be liable, though.
I appreciate that information.
You're quite welcome. And hopefully, please reach out. I'd love to have a conversation with you, Oliver, about your personal situation.
Definitely.
Well, I want to thank everybody. Unless there's any other questions that was not addressed, I did put the link in the chat section. You have one more question.
I have one question.
Can I speak? Shelley?
Shelley, let Carolyn go first.
Okay.
Okay, hello, good evening, Dr. Cedric. I wanted to ask something. A few years ago, we call ourselves doing something through LegalZoom. So there is a little problem there because they weren't quite as detailed as you were saying here tonight. What I wanted to know is I had clicked on the calendar, but it wouldn't give me a time. But I'll call you and see if I can set up a time to discuss that, because we may have to start over from the beginning.
Okay, and so Carolyn, I do apologize that you said the link wasn't working for you for some reason. If the link
Right.
doesn't work, please just call this number and my reception team will answer, and they have access to my calendar and they will manually by hand put you in.
I appreciate that.
If the link doesn't work, they'll do that, but I would love to have a conversation about you, about your family, about what you put in place, and we could take a look at it to see, can it be salvaged? We can look at it. Or
Okay.
do we need to, or do we need to start all over? And we'll discuss it and we'll let you determine. Now, do you have a significant other or is it just you?
Yes, my husband.
Okay, so please, if when you schedule a call, please try to schedule a call where you both can be on the call together. So that way we can discuss both of your wishes kind of together. And that'll be the best way for us to move forward.
Okay, great. Thank you very much.
You're quite welcome. And I'll look out for your appointment.
Okay, thank you.
You're
Okay,
welcome.
Shelley.
Thank you for allowing me. Thank you so much for this webinar. To just quickly, I just made the appointment to speak with you tomorrow.
Okay.
Should I have my niece, who I want to be my beneficiary, to be in the call with me? Is that important, or should we just talk about it then, or would it be beneficial if I get her to make sure that she's on the call with me? Because if I need to do that tonight, because she's back east, and I just wanted to ask that question.
Okay. Well, because your niece, this will be all your plan. Your niece does not need to be on the call at all. Now, we'll discuss when you can bring her into the loop and let her know you don't want to keep her in the dark. But ultimately, it's up to, because it's your plan, it's up to you. You can have your niece on board if you want, if you just want her to listen in to the process. But we can start with just you and I with the call, so I can let you know, we can discuss your personal situation. And if we get a plan in place, we can definitely loop your niece in. Absolutely.
Okay.
But it's not mandatory or required that she be on the call tomorrow.
Okay, and then one other little thing I just wanted to kind of address this. I had a friend, she lived with her grandmother, and her grandmother left her her property. She just, she said she willed it and she wanted her to have it. And she wound up losing it because when her grandmother died, she was unemployed and she didn't qualify for the loan to assume the property. How can you address that a little bit? I mean, it was like, okay, here you are, here's the house, but she couldn't assume the loan that she had. For example, just say her loan was like maybe 5%. And now when she died, the loan is 25%. She wasn't able to assume the loan that her grandmother carried all that time. And can you just kind of address that a little bit?
Yes,
Please.
really quickly. That happens a lot. When you pass away, there's a clause that we put in your trust or in the will that says subject to mortgage. And that's usually in how we do it. So when you pass property that's subject to the mortgage, if there is a mortgage on there, whoever the beneficiary is now responsible for that mortgage. If they can't get the mortgage because of credit or what have you, they can sell the house. Hopefully there's equity. Okay, they can still sell the house. So that's the alternative. If the house has family value and sentimental value, it can be tough, right? Because now she was gifted the house and now she can't afford it because of whatever reason, right? But that is up to the person leaving the house. Because the person leaving the house, if they had a life insurance policy, they could have used other assets from her estate to pay off that mortgage. If they knew how to do it the right way, if they didn't want the person inheriting the house to have to worry about a mortgage. That's also part of your estate planning, right? So there's ways that we can plan to use other things to pay off that house. So when she died, the life insurance pays off the house, and now the house goes free and clear to the beneficiary. But if you don't have a plan and you just give a house outright, if there's a mortgage attached, if you can't come up with the loan, you have to sell the house.
Right. So what I'm saying that, so she couldn't even assume the loan.
Yes, so that's what I'm talking about here. If you take it subject to the loan, you have to be able to get a loan to pay it off. And if you can't qualify for it, then you have to sell the house. You have to.
Oh, so she couldn't continue on her loan. She had to bring the loan to her.
Yes, because she has to qualify.
understand.
She has to qualify credit wise.
Right.
So and the mortgage lender could look at her and say, hey, well, we like grandma, but we don't like her. So the
Right.
mortgage lender has no obligation to give the beneficiary that loan.
That's
No
right.
legal obligation whatsoever. In most cases, what happens is the beneficiary goes out, they get their own financing through their own bank, and they pay off the old loan, and they have the new loan.
Right.
That's the way it happens 90% of the time.
Okay. Thank you for answering that.
You're quite welcome.
Yeah.
Well, again, I thank everybody for joining us tonight. The information shared, we feel is very informative, and that's why we do this on a monthly basis. So when we do it again, because we have your contact information, you may get an invitation to attend it again or share this invitation with someone else. Our goal is to make sure that as many people know, because we die, why things happen to us because we don't know. And we don't want that to be the reason for you to not have your estate in order because you don't know. So again, thank you everybody very much. Thanks, Cedric. Thank you again for your presentation.
Thank you.
And have a wonderful evening.
Thank you so
Thank
much.
Take
Have a
care.
good night, everyone.
Thanks, everyone. That was great.
Thank you. Good night.
Good night.
Night. Oh, that was good.